In the last video, I introduced the Title VII of Civil Rights Act of 1964 and some amendments including Pregnancy Discrimination Act, PDA, Age Discrimination in Employment Act, ADEA, to help avoid discrimination against protected groups at the workplace. However, there are some situations where it is legal to discriminate if you can prove bona fide occupational qualification. So today, we will talk about definition, rules, and cases of BFOQ. First of all, what is BFOQ? BFOQ are employment qualifications that employers are allowed to consider when making hiring and retention decisions. This is an important exception and a complete defense to the Title VII of the Civil Rights Act of 1964 and its amendments. So to defend yourself from discrimination as an employer, you have to prove that the qualification is related to essential job duties and is necessary for your normal operation of your business. The qualification can be chosen based on religion, sex, national origin, age, pregnancy status. So what are some rules to determine BFOQ? There are three that you have to prove. First of all, you have to prove the direct relationship between protected traits and the ability to perform the duties of the job. So the protected traits including, as I mentioned, religion, sex, national origin, etc. And the second, you have to prove that BFOQ relates to the essence or the central mission of the employer's business. And the third one is you have to prove there's no less restrictive or reasonable alternatives. So then I would like to share some of the cases. First of all, for gender, I mentioned Hooters in the first video, where a few men actually were turned down when they applied for the service position in 1997 at Hooters. And so then they filed a lawsuit on discrimination, which were later combined, those cases were combined into a class action lawsuit in Chicago. Do you know how much did these cases cost the Hooters? They actually settled the litigation for $3.75 million and agreed to create several gender-neutral positions. Later on, Hooters was sued again, but settled again with its hiring practice. So until today, Hooters still use the BFOQ to defend their gender requirement in their service position. And the second case is age. Greyhound actually argued that they don't want to hire people between the age of 40 to 65 because they are responsible for public safety, and some of their specific argument includes that there are 24-hour on-call duty for the new drivers. Based on the union agreement, the new drivers actually work the actual board until they have sufficient seniority. And second of all, the age actually impact the ability to perform for instance, increase difficulty in the night driving, increased likelihood of heart attack, and they also argue that for heart attack, it's not easily detectable during the physical exam. So their argument is it's dangerous to hire the older drivers. And the ruling is arguing that you can't make the employment decision merely on the base of the age. So several factors have to consider together. And the third case is in regards of religion. So one of the private helicopter company, they hire a pilot to work with Saudi Arabian government. And the driver, Kern, he was recruited as pilots to fly patrol missions along the pilgrimage route to Mecca. Because such flights enter the holy area around Mecca, and because the Saudi law actually specified that beheading as the penalty for non-Muslim entering this area, so a condition of the employment was that the pilots have to be Muslim. Therefore, there are a lot more details, and I'll share the link of the case. So the results of the court decision is that Dynalectron, the company, did not breach the contract with Kern. So in this case, the religion was proved to be BFOQ. And the next case is pregnancy. So Johnson Controls have a very special policy that they are excluding fertile women from working in battery manufacturing jobs because they argue the battery contains high amount of lead, which entails health risk to people's reproductive system. So they don't let the female at a certain age to apply for the job. However, there is a very interesting fact is that it impacts people's reproductive system for both men and women. So the ruling of this case is that the company's gender-specific rule was biased and inequitable because they permitted the fertile man, not the woman. So it is the company's role to tell the job applicants that this job, the task will expose you to the risk to the risk to the environment. However, they can't exclude them from applying for the job. And last, the national origin. A lot of federal jobs actually only require U.S. citizens to apply the job. And this could be an example, but this also is supported by the executive order that only U.S. citizens can apply for the federal jobs. And lastly, race and color. It is not specifically mentioned in the qualification under Title VII. So theoretically, employers can't make the case to relate race or color with the business operations, and therefore they can't be discriminated legally based on the race or color. However, there are cases where, for example, casting require certain race or color information when they're looking for actors for specific roles. How do they make the case then? What do you think? Leave your comments below, and I will share some information in regards of BFOQ in casting industry later.